Hi, I am Justice DK Seth. Uh,
Welcome, sir.
I have some problem with the video. I could not, my video is not being connecting. So I can hear you and see you. I believe you can hear me also. Therefore, please
Yes,
forgive
sir.
me for not being able to operate my video.
Yes, sir. We can hear you. So I believe that's a glitch with the. I believe that's a glitch with the Cisco WebEx app per se. So if you, so what we may do is if there's a, so apologies, sir. So if there's any another device available, otherwise there's
No,
no, sir. Otherwise
I
there is no
do,
problem, sir. There's
I
no
do have
problem.
I do have a phone only, iPhone,
Okay,
but I don't have any other device.
okay, then there is no problem, sir. It is indeed a pleasure to have you amongst us, sir. There is no problem, sir.
Yes,
We feel honored, sir. Thank you so much for your presence. Thank you.
thank you. No, I had the WebEx downloaded, but I do not know where it has disappeared today. I'm sorry. Unfortunately, today I find that it has disappeared from my icons,
No,
and
no
it's
issues.
reporting that this camera cannot be detected.
Yes, sir. So this is a glitch. This is a common glitch that we have been
Yes.
facing from last three days, sir. So we understand, sir. So no, not an issue, sir.
All right.
Thank you, sir.
Thank you.
Respected judges, we are just waiting for all the judges to join. Then we'll begin with the final round.
All right. All right.
Okay.
All right. So let me do one thing. Let me restart the laptop and see whether it can be revived.
Sure, sir. Whatever you feel suitable, sir. Honorable judges, we are waiting for one of our judge, Dr. Rajesh Chaudhary, sir. He is about to join us. Sorry for the delay. Yes, sir, you're
video.
visible now. You're very clear, sir.
Yes.
Yes, your video is very clear, sir. Thank you, sir. Thank you so much.
After restarting, it has revived.
Yes, indeed, sir. I believe
Welcome,
that's
everyone. Greetings to everyone.
greetings, sir. Greetings.
And I'm seeing, I don't know their identity. Would you please mind to introduce yourselves one after another?
Your Lordships, my name is Supinder. I am speaker number one from the appellant side in the present case.
Acha. You are Supinder.
Yes, sir.
Good.
Supinder.
Greetings of the day to your lordships. I am Arkash. I am speaker
Yes.
number two from the side of the appellant.
Akash. Well,
Arkash, your lordship.
Orkash. Acha, Arkash. Welcome, Arkash.
I am grateful to you, your lordship.
Appellant's researcher, if they may just introduce themselves.
Yes.
I think the appellant researcher couldn't connect. I am Sebin Sebastian. I am speaker number one for the respondents.
Yes.
Your Lordship.
Your name, please?
Sebin Sebastian.
Please?
Sebin Sebastian.
Acha. And I see Dr. Rajendra Dhar. Greetings to you,
Yeah.
Dr. Dhar.
Greetings
Nice,
to you as well. I
nice
reciprocate
meeting you.
warm regards to you.
Nice meeting you.
Thank you very
And
much.
I also see Dr. Bishi Rathore. Welcome, sir.
Good afternoon, sir.
Greetings of the
I'm very
day.
happy to be here with you.
It's nice meeting you.
Better.
It would have been a great pleasure if I was there and physically, and we could have met each
Yes,
other.
certainly.
Yes, yes.
That's
And
quite a
Mr.
great
Abhishek,
process, sir.
Mr. Abhishek Mishra, greetings of the day. Welcome, sir.
Thank you, sir. Thank you for gracing this moot court. We are really grateful and indebted to you, sir. Thank you so much.
No, I'm sorry I'm late because I came back just
No,
10
you are
minutes,
absolutely on
10
time, sir.
minutes to 30.
No, thank you. Thank you so much.
No, if I had knew it, then I would have cancelled my arbitration. But it was at a very late stage, and therefore I could not do that.
We sincerely apologize, and we really appreciate
No,
you
no.
giving us your positive note to join.
It's a great privilege on my part to associate myself with all of you.
Same here, sir. Right.
And when a person becomes old, he wants to find new blood. Therefore, I enjoy the company of younger generation.
We too, sir. We seek wisdom from our seniors.
Provided I do have that wisdom.
Old is gold always.
Let us see. Thank you for the compliments.
Thank you.
Greetings, Your Lordships. My name is Joel. I am speaker number two appearing on behalf of the respondents.
I see. Nice meeting you. You are Mr.
Joel.
Joel.
Good afternoon, Your Lordships. I'm Samuk B. Ram. I'm the researcher for the respondents.
Good. Welcome, Mr. Ram.
Thank you, Your Lordship.
I also welcome Mr. Joel.
Much obliged, Your Lordship. It's a pleasure to be here today.
It's my pleasure too.
Welcome, judges and participants.
Yes.
With due permission of the judges, if they permit, shall we begin the round?
I'm sorry, Shwani. We are still waiting for one more judge. We have contacted them. And they'll be joining us shortly. Apologies for the inconvenience caused. Dr. Chaudhary sir will be joining us within the next 2 minutes. Thank you.
All right.
Yes, sir.
আলোটা দেবেন।
A very good afternoon to everyone present here. A very hearty congratulations to both the teams for being qualified for the finals. And it is indeed an honor and pleasure for us to have a 5-judge constitution bench with us today, consisting Dr. Rajendra Dhar, sir, Additional Labour Commissioner, Labour Department, Government of NCT of Delhi, Mr. Bhuvan Chandra Rathore, sir, former Deputy and Joint Registrar, Trademarks and GI, Government of India, Dr. Rajendra Chaudhary, sir, District and Sessions Judge, Tonk, Rajasthan, Justice Dilip Seth, former Judge, High Court, Allahabad and Calcutta, and Mr. Abhishek Mishra, sir, PhD scholar, University of Hamburg, Germany, the very man behind the composition of the Moot proposition of the 4th Surana and Surana and School of Raffles University label of Moot Competition 21. We welcome you all judges, and with the permission of the judges, the court masters may begin with the proceedings. Thank you, sir.
Yes. Yes, you may proceed.
Proceed.
Now, Miss Sivangi was proposing something.
Yes.
Yes, what do you say?
Welcome, judges and participants. With due permission of the judges, can we start the proceedings?
I believe we are ready. You may proceed.
Thank you, sir.
Am I clearly audible and visible to your lordships?
Yes, Mr. Shubhinder.
May it please the Honorable Court, the Council seeks permission to address the bench collectively as your lordships.
Sure.
Warm greetings to your lordships. This is Council number 1, appearing on the behalf of the appellant, Raffles Private Limited. In the present case, the Honorable Supreme Court of Hastinapur has clubbed 2 SLPs which were filed by the Raffles Private Limited against the orders of Honorable High Court of Andhra Pradesh. The council seeks to know if your lordships are already well versed with the facts of the present case.
Yes, we have gone through it. Now we are concerned with the Moot questions that involve. You may proceed on that.
Sure, sir. Then the council seeks permission to briefly state the division of issues between the speakers.
Yes.
I'm grateful, your lordships.
You proceed in your own way.
Sure, sir.
You need not ask for permission every moment.
Your lordships, this honorable court has identified 3 specific issues in the present case, which are mentioned on page number 12 of the Moot brochure. I shall first deal with issue number 1, where I will prove that the government notification dated 1/1/2016 under the Employees Compensation Act is not applicable to accidents that took prior to the passing of that notification. Your lordships, then my co-counsel over here will move forward with his submissions on issue number 2 and issue number 3, where he will eventually prove that the claims under the Employees Compensation Act and the rules for commercial drones are not mutually exclusive. Further, he will prove that the rules for commercial drones are unconstitutional. So if your lordships permit over here, the council may finally start with the arguments on issue number 1.
Yes, please.
Yes,
I'm
please.
grateful, your lordships. My first contention under issue number 1 is that the claim of legal dependence of Shri Apar Shakti was not at all maintainable before the DC, sir. So section 10 of the Employees Compensation Act makes it very, very clear that no claim for compensation can be maintained by a commissioner until and unless notice of the accident has been given to the deputy commissioner and unless the claim is preferred before him within 2 years from the date of the death of the employee. So what section 10 does over here is that it specifies a period of limitation of 2 years for filing a claim. Your lordships, in the present case, the road accident of the lorry and the death of Mr. Shri Apar Shakti took place on August 3, 2014. From this date, the LRs of the deceased employee had 2 years time for filing the compensation before the DC. But sir, they filed the compensation only on August 10 and 2018. So there was effectively a delay of 615 days on their part to approach the deputy commissioner appointed under Employees Compensation Act. Your lordships, over here, the judgment in the case of Postmaster General versus Living Media India Limited, which was reported in Supreme Court cases in 2012, is of supreme importance. In this case, your lordships, the Postmaster General had filed an appeal against the order of the Honorable High Court of Delhi after a delay of 427 days. So while rejecting the appeal of the postmaster, the Honorable Supreme Court had discussed the law on condonation of delay in detail and observed that the condonation of delay is an exception and that the onus to show that the sufficient cause exists for such condonation lies upon the applicant. Furthermore, your lordships, it is well settled law that everyday delay has to be explained while seeking condonation of delay. At this juncture, your lordships, the council most humbly contends that the legal dependents of Shri Apar Shakti in the present case have provided no sufficient cause to justify the delay of almost 700 days in filing the claim. So the claim was not at all maintainable before the deputy commissioner and he has blundered in awarding the claim to the LRs. Moving forward, your lordships, my second contention under issue number 1 is that the gadget notification cannot have a retrospective effect unless it is specifically mentioned over there. Your lordships, in the present case, The primary bone of contention between the opposing parties in issue number 1 is that the notification that was issued by the union government on 1/1/2016. Your lordship, this notification was passed under Employees Compensation Act section 4. What this notification did was that it changed the ceiling of rupees 5,000 monthly wages to rupees 10,000 for the grant of compensation by the DC. On the basis of this notification, the Honorable High Court of Andhra Pradesh decided that the compensation that is to be given to the LRs of Shri Apar Shakti needs to be doubled. But sir, over here it is brought to the Honorable Court's attention that the impugned notification is not a legislative act, but merely an executive order, sir. So the union government has been provided with this authority to issue this notification by the Employees Compensation Act. So we can say over here, your lordship, that the impugned notification of the union government is a form of subordinate or delegated legislation. So at this point, I would cite the case of Hukum Chand versus Union of India, which was reported in 1972 Supreme Court cases. In this case, sir, the Honorable Supreme Court had observed that a delegate cannot exercise the same power as the legislature unless such power has been expressly and impliedly conferred upon the delegate by the delegation. Sir, in the present case, it is most humbly submitted that the language of section 4 of the EC Act, Employees Compensation Act, which gives the power to issue notification, does not show any legislative intent on the part of legislature to authorize the union government to pass notifications with retrospective effect. So, sir, in the case of Panchi Devi versus State of Rajasthan, which was reported in 2009 Supreme Court cases, the Honorable Supreme Court very clearly observed at this point of law that delegated legislation is ordinarily prospective in nature, and a right or liability already created for the first time cannot be given a retrospective effect. So, your lordship.
Mr. Supinder, I'm sorry for interruption. You are
All right,
citing
sir.
cases, but without referring to the page number, because whenever you cite a case, you must cite the page number also.
Sure, sir. Sure, sir. Sir,
Yes.
if your lordships may permit, I may specifically cite the page numbers of the two judgments I have already cited.
No, you continue with it. Next time you do it, but we are
Sure.
accepting it as it is. You need
Sure,
not
sir.
go
Sure,
back.
sir.
You can proceed, but next time you will give us the page number also.
Sure, your lordships. The reason I was not quoting the page numbers was that we have already submitted the written submissions in the forms of the memorials.
Oh, I
So
see.
that's why
All
I
right.
am omitted the page numbers.
All right, all right. You can proceed in your own way. All
I'm
right.
grateful, your lordships.
All right.
Your lordships, the parliament and the state legislatures possess the power to enact legislation with the prospective as well as a retrospective effect. But sir, the same does not apply in the case.
Mr. Supinder, could you please read out section 4 provisional clause for us?
Sure, sir.
See,
Sir, the proviso provides that provided that the central government may, by notification in the official gazette from time to time, enhance the amount of compensation mentioned in clause A and B. So it by implication means that A and B of section 4 subsection 1, sir.
Please argue again what you're trying to argue. I perhaps failed to understand.
Your lordships, the argument primarily was that the union government is getting its power to issue notifications under this specific proviso. So unless and until this specific proviso gives the power to the central government to issue notifications with retrospective effect, that cannot be done because the Honorable Supreme Court has passed clear judgments in that regard, especially the case of Panchi Devi versus State of Rajasthan, sir. In this case, the appellant had filed a writ petition before the Rajasthan High Court for getting family pension after her husband's death. Sir, her husband was employed with the state government. This got dismissed, so ultimately the case landed in the Honorable Supreme Court. So, sir, the case of appellant was that the government had started a pension scheme after the death of her husband, of the appellant's husband. So, sir, the scheme, even though was started after the appellant's husband, death of the appellant's husband, the appellant claims that she should be provided with the compensation under that scheme, a pension under that scheme, but the Honorable Supreme Court argued otherwise, sir. Sir, in reasoned otherwise in its judgment, the court held that the notifications always have a prospective effect unless and until it is specifically mentioned in the delegated legislation that it can have retrospective effect. So, sir, basing on that, the proviso nowhere states that the notifications under the proviso of section 4, subsection 1 can have a retrospective effect. So, sir, by necessary implication, it means that the notification dated 1/1/2016, which was issued by the Union government under that specific proviso, cannot also have a retrospective effect, sir. If your lordships are satisfied with the answer, the council seeks permission to move forward.
Yes, yes.
Please go ahead.
I'm grateful, your lordships. Moving forward, your lordships, my third contention under issue number 1 is that the Honorable High Court of Andhra Pradesh was incorrect in doubling the amount of compensation to legal representatives of Shri Apar Shakti. Your lordships, as I have already stated earlier, the death of Shri Apar Shakti took place on August 3, 2014. So the cause of action to file the compensation under the Employees Compensation Act also arose on the said date. So, sir, on that specific date, the monthly wage applicable for calculating the claim under the Employees Compensation Act was rupees 5,000. And the compensation amount according to those wages, that is 5,000, comes out around rupees 11 lakhs, sir. So now it is immaterial that later on Union government came out with a notification that increased the monthly wages, because this increase has been brought about by a gazetted notification, and such notification, as I have already argued in my submissions, cannot have a retrospective effect. So, sir, the maximum claim that can be awarded to the LRs of Shri Apar Shakti, even if we condone the delay, which is specifically of 615 days on their part, the compensation, max compensation, can only be 11,06,850 rupees. So, your lordships, the basic logic behind calculating the amount of compensation on the date of death is that the dependents of the deceased employees should get compensation according to the prospective earning capacity of that employee at the date on which he died. So, sir, it follows from this logic, this basic logic, that the prospective earning capacity of a deceased employee must be calculated from the date of the death of that employee, and not from some arbitrary future date when the government comes out with a notification, sir. So therefore, it would be wrong to argue that the Union government can retrospectively change the laws, the parameters of calculating the compensation under Employees Compensation Act by just issuing a notification. So, sir, moving forward, furthermore, Section 30 of the EC Act provides provisions relating to the appeal from the order of the Deputy Commissioner. Your lordships, it is most humbly contended over here that the scope that the appeal that is provided by Section 30 of the EC Act is very, very limited, sir. The said subsection, said Section 30 very clearly provides that the award of commissioner can only be challenged in the appeal if there is a substantial question of law involved. So in the present case, there was no such substantial question of law. There was the question was only relating to the application of facts, which was already properly done by the Deputy Commissioner of the EC Act. So, sir, the claim awarded by the DC lacked the essential element for challenge in an appeal. So the Honorable High Court erred over here by admitting the appeal when there was no substantial question for appeal. So, sir, therefore, in conclusion, it is argued that government notification cannot have retrospective effect, and due to the limited scope of the appeal allowed by Section 30 of the EC Act, it is most humbly submitted before this Honorable Court that the Honorable High Court was wrong in doubling the amount of compensation to be paid to the LRs of Shri Apar Shakti. With that, I conclude my arguments on issue number 1, and the council is open to all and any queries that your lordships may have on issue number 1.
Therefore, your first ground is
Yeah.
limitation. That
Right,
it is delayed by 616 days
right,
and
sir,
was
right.
filed and the delay was not properly explained, and each day's delay has not been properly explained. And second was that this
Retrospective.
notification cannot be have retrospective effect until and unless the power of delegation legislature provides that relaxation to give retrospective effect.
That's right, sir.
It's all
So
right.
those are the three contentions, along with the third contention that the power of appeal under Section 30 is very
Yes,
limited.
sorry.
Very
The power
correct.
of appeal is also with the.
Limited.
You have argued that it is with the deputy commissioner, from deputy commissioner to the commissioner. That appeal is preferred before the commissioner.
Sir, from Deputy Commissioner to the Honorable High Court, Section 30 mentions about the appeal to the appellate authority,
But
and
that is only on the question of law, substantial question of
Right.
law, not.
right.
All right.
No, as a matter of fact, just to share with my young budding legal people who are coming up in the field, as far as Employee Compensation Act 1923, the appeal is concerned, the appeal squarely lies only before High Court, not before the Commissioner, because I
Right,
have
sir, right,
myself
sir.
handled these quasi-judicial courts for
Yes.
11 years in Delhi, and whether it's a substantial question of law or facts, or be there any other issue connected with the case, whether it is accidental or it is a fatal accident resulting into death, the appeal fully and completely lies only with High Court, not with any other junior authorities or commissioner, including Commissioner one. Number two, I would like to comment. This has been beautifully brought out as far as government notification is concerned. As a matter of fact, in almost 100% cases, no government notification has a retrospective effect as such until unless it is mentioned there. Rarest of the rare. For the last 30 years, I have not seen any government of India notification which has a retrospective effect, at least for the last 30 years that I have served in the government. And all such notifications concerning the policies under various labor laws, or for that matter, any other labor laws, has definitely a prospective effect. One. Number two, the point of concern, that is delay of 2 years. There is a capping in the act itself which lays down 2 years capping for filing the claim before the notified compensation commissioner, until unless there are cognate reasons for delay, justifiable reasons for the delay, only then that too has to be decided with the
student argue
compensation
their
commissioner.
part, and then we can say, because the other party has to make the argument. Then
That
Yes,
has also been
that's right.
brought out completely beautifully.
Dr. Dhar,
And
what Mr. Mishra is saying, that let us hear the students, and then
obviously,
then
the other part also has to be heard
yes,
properly,
yes.
completely. These
And
are
it's-
my inputs, and that we go to the other side also. Please.
Thank you for the inputs. Thank you for the inputs. It's all right. Let us hear the lawyers.
Yes, please. Yes, please.
The lawyers now. Let us hear them.
It was a pleasure arguing before the honorable bench.
Yes.
The council solicits permission to address the bench collectively as your lordships.
Yes.
The council would first like to know, your lordships, that is the council clearly audible and visible?
Yes. You are audible and visible.
Much obliged, your lordships. May it please the court, warm greetings of the day to the honorable bench and my friends. This is Arkash as counsel number 2, appearing on behalf of the appellants, representing RAPS Private Limited, in 2 special leave petitions, your lordships, filed under Article 136 of the Constitution of Hastinapur before the Honorable Supreme Court, clubbed by the Honorable Court for the purpose of hearing by virtue of Article 139A of the Constitution of Hastinapur. Taking the discourse from my co-counsel now, I shall hereby address the second and the third issues respectively. Hence, ultimately contending, your lordships, that the appeals filed by RAPS Private Limited are consistent with the law of the land and must be duly considered and upheld by the Honorable Court. Your lordships, the council thus humbly solicits permission to begin with the arguments on issue number 2.
Yes.
Much obliged, your lordships. Your lordships, I would hereby like to begin with this beautiful quote, that the immature notion that 2 things are mutually exclusive and that one can't exist when the other does without understanding any one of them is a disservice to both of them. Your Lordships, the Council would thus assert that the claims under the Employees Compensation Act 1923 and the rules for commercial drones 2016 are not mutually exclusive, and it is unreasonable for one to reach at such a conclusion without deep diving into how the two of them operate, Your Lordships. Your Lordships, it is duly submitted in accordance with rule number 28 of the Drone Rules 2021, of which the applicable provision in the Moot proposition, that is rules for commercial drones 2016, is peri materia, that in matters, and I'm quoting this from rule number 28 of the draft drone rules, in matters relating to third party insurance of drones and compensation in case of damage to life and or of property caused by such a drone, the provisions of Motor Vehicles Act 1988 apply mutatis mutandis. Your Lordships, thus for considering claims under rules for commercial drones 2016, one would have to give due consideration to the Motor Vehicles Act 1988. Having made that clear to your honorable lordships, in order to make an elaborate and exhaustive argument before the honorable court, I have divided the issue in 5 primary limbs, your lordships, which shall be dealt by me one by one. The first limb of my arguments, your lordships, pertains to the fact that claims can be mutually made under Chapter 10 of the Motor Vehicles Act as well as the Employees Compensation Act. I would like to begin by quoting this precedent of Oriental Insurance Company Limited versus Daya Mavya and others, which was reported in the Supreme Court in 2013. Your Lordships, in this, a certain Mr. Yalgudappa, he was employed as a pump operator in the mechanical engineering department of a company. Now, while riding pillion on a motorcycle, during the course of discharging his duty as the employee, he met with an accident which proved to be fatal later on, your lordships. Mr. Yelgudappa had died on the spot. The tipper was insured with Oriental Insurance Company Limited, the appellant in the case that I have mentioned. What is interesting to this authority, your lordships, is that Daya Mavya, the widow and the dependents of Mr. Yelgudappa, filed a claim petition under Section 166 of the Motor Vehicles Act 1988. And the plea taken by the insurance company was that indemnification must only take place through the Employee Compensation Act and not through any other provision, including the Motor Vehicles Act. Now, what is important is for us to consider that the court in this case was of the view, and it has been mentioned in paragraph number 16, that the choice of forum cannot deprive the victim of his rightful compensation, your lordships. Now, if a person is entitled to be given compensation under the Employee Compensation Act, your lordships, he simultaneously cannot even be deprived of his rightful compensation under the Motor Vehicles Act, thus proving that both of them can exist concurrently as opposed to being mutually exclusive. Your lordships, the nature of claims under the Motor Vehicles Act is such that the victim is entitled to choose any one of the two fora depending upon the benefits that he might get from either or both of them. But insofar as the claim under the Motor Vehicles Act specifically is concerned, the claimant should establish that he is entitled to approach the court under Section 166 by establishing that he was not himself the tortfeasor. The question in this case, this particular question, plays a vital role in distinguishing the claims made under the Motor Vehicles Act as well as the Employees Compensation Act, your lordships. Thus, a person, your lordships, having proven his rightful claim over compensation under the Motor Vehicles Act is entitled to it regardless of whether or not he has been compensated under any other forum, your lordships. Thus, if the nature of compensation under these two acts, I am talking about the Employees Compensation Act as well as the Motor Vehicles Act, is so different, thus rightful claims can be established under both simultaneously or any one of them. Your lordships, how can the two of them in this case be mutually exclusive, I ask? Coming back to the Oriental Insurance Company case that I just cited, the court dismissed the appeal of Oriental Insurance Company Limited and observed in the last paragraph of the case that both the appeals have to be applied and both the compensations regarding the compensation under Employees Compensation Act as well as the compensation under the Motor Vehicles Act have to be applied in order to present an adequate compensation to the victim, your lordships. Now, regarding Section 167 of the Motor Vehicles Act, your lordships, the said section gives the claimant, even under the Employees Compensation Act who has been compensated, the right to invoke the provisions of Chapter 10 of the Motor Vehicles Act and deals with what is known as no fault liability, your lordships, in case of an accident. Section 140 of the Motor Vehicles Act 1988 imposes a liability on the owner of the vehicle to pay compensation fixed therein, even if no fault is established against the driver or owner of the vehicle, your lordships. Now, in this particular case, Cutting Edge Technologies Private Limited was liable to provide for the drones that were operational. Now, any human intervention, it is mentioned, would be done by Cutting Edge Technologies Private Limited. Now, those are the drones that Cutting Edge operates, and those are the drones that fell on the two employees of RAPS Private Limited, and they have died. So they have the rightful claim under Section 140. Now, Section 143 re-emphasizes what is emphasized by Section 167 of the Act as well, that the provisions of Chapter 10 of the Motor Vehicles Act 1988 would apply even if the claim is made under the Employees Compensation Act, your lordships. Thus, your lordships, concluding this very limb, the provisions of Chapter 10 of the Motor Vehicles Act 1988 also apply in relation to any claim or compensation in respect to death or permanent disablement of any person under the Employees Compensation Act, resulting from an accident of the nature referred to in subsection 1 of Section 140 of the Motor Vehicles Act. Therefore, it is most humbly submitted before the Honorable Court that the claims under the Employees Compensation Act 1923 and the rules for commercial drones 2016, claims under which have to be made under the Motor Vehicles Act, cannot be mutually exclusive, your lordships. Now, before moving on to the second limb, I am open to any and all kinds of queries that you may have regarding what I have presented till now.
No, I have no query. You may proceed.
Please
I
go
have a
on.
query.
Go ahead.
Well, the drone rule says about this, the possible compensation.
The drone rules explicitly, your lordships, mention the fact that the compensation to be paid under the drone rules has to be complied with the rules of the Motor Vehicles Act. And that is why we are relying upon the provisions of the Motor Vehicles Act when it comes to dealing with the compensation of the ones who have been hurt with respect to the operation of drones, your lordship. If I have been able to satisfy the court, may I please proceed with the second limb of my arguments?
I think you have. Could you please specifically mention the rule number?
Learned Counsel, I would like to ask from you. You cited Rule 20, Part 10 insurance under the Drones Rule 2021.
Sure, your lordship.
It reads, the provisions of the Motor Vehicle Act 1980 and rules made thereunder shall apply mutatis mutandis to third-party insurance of drone and compensation in case of damage to life and property caused by such drone. All right. After this argument was made or plea was taken before Honorable High Court.
Could your lordship please repeat the question that you just...
I just wanted to ask Learned Counsel whether the plea regarding Rule 28 under the Drones Rule 2021 was pleaded before the Honorable High Court or not?
Your lordships, it indeed would have been pleaded before the Honorable High Court. We do not have the access to the relevant documents of the High Court since we are in appellate jurisdiction of the Supreme Court. So that is why we are dealing the case at the face value. But considering Honorable Lordship's query, which particular rule your Lordship asked of the drone rules specifies that Motor Vehicles Act is the applicable law. It is your Lordship rule number 28 of the drone rules, which specifically mentions that provisions in terms of compensation to be paid by accidents of drones has to be the same, has to be given due regard to with respect to Motor Vehicles Act section 167 and 168, your lordship. So if I have been able to satisfy the court, can I please proceed further to the second limb of my argument?
A small intervention here.
Sure, your lordship.
From my side, in case of a death of an employee, it may be a formal or an informal relationship with the employer and employee concerned. See, there is loss of life if a person loses his, in case a person dies, there is a loss of life. Now, question is, can there be two compensation under two different legislations? One under the EC Act, another under the motor vehicle accident, depending upon the drone rules. That needs to be looked into deeply. I'm just giving my inputs on that. We can proceed further.
Could I please answer your lordship's query?
Yes, if you feel like, if you are prepared, you may do so.
Sure, your lordship. I'm grateful for your question, your lordship. Your lordship, I'd like to direct your attention to the Moot proposition. The specific part of the Moot proposition says that the deputy commissioner, when the legal dependents of the ones who deceased on the premises of RAPS Private Limited asked for compensation, directed RAPS Private Limited, my client, to pay for compensation, your lordship. My client in return asked Cutting Edge Technologies to indemnify because the accident took place because of their own liability, your lordship. So that is why we are asking for indemnification of the losses from the concerned party. So that is why we have claimed all of this in this very part, your lordship. If I've been able to satisfy the court.
All right. You may proceed further.
I'm obliged to you, your lordships. Now moving to the second limb of my arguments, your lordship, which is perhaps the most important element of my arguments herein. Your lordships, I shall argue that third-party insurance is mandatory for medium drones in accordance with the drone rules. Your lordships, it is most humbly submitted that no person can use, except as a passenger, or cause or allow any other person to use a drone in a public place unless there is in force a policy of insurance complying with the requirements of Chapter 11 of the Motor Vehicles Act, which is explicitly mentioned, your lordships, in the drone rules, your lordships. Now, and it is mentioned in the Motor Vehicles Act, Section 146 as well. Now, when you are not entitled to use a drone without being insured, I would direct your lordship's attention to page number 2 of the Moot proposition, paragraph number 9. Are your lordships with me on this?
Yes.
Yes.
Your lordships, paragraph number 9 explicitly mentions that Cutting Edge Technology, the technology company that was responsible for operating drones, applied for certification of drones in the category of medium drone at the Quality Control Council of Hastinapur. The council accordingly granted it permission to operate these drones. Now, a reasonable inference that can be drawn by the court to this provision is that if they are duly certified and they have gotten their drones certified in the category of medium drones, and the Quality Control Council has duly assessed their drones, it must be inferred reasonably from this that they must possess the third-party insurance that the Motor Vehicles Act makes it compulsory for the operator to have a third-party insurance. So in this case, we can reasonably inference that the said third-party insurance is applicable in this particular case. The said third-party insurance shall be used for indemnification of the compensation of RAPS Private Limited, my client, your lordship. The expression third party in this particular case means persons other than the contracting parties to the insurance policy, your lordships. Now, I shall direct your lordship's attention to the second part of my argument in this limb, which is that since we have claimed that there was a third-party insurance that had already taken place, the insurance company therefore is liable to pay for the indemnification of the losses incurred, your lordships. All those engaged in loading and unloading of goods in a drone are using the drone during such time, your lordships. Now, therefore, any accident arising during loading and unloading will also be an accident arising on account of the use of that vehicle, your lordship. Now, in the Moot proposition, it has been specifically mentioned that the technology company ensured my client that there would be no human intervention required on the part of my client, since my client is using their technology for delivery of his own goods. Your lordships, any human intervention was to be done by Cutting Edge Technologies Private Limited, which implies that on their part, the fault has been established during the loading or unloading of the goods. Some kind of a technical glitch on their part occurred, due to which it fell on the employees of my company, my client's company, your lordship. Now, in the present case, your lordships, since the accident in the present case arose out of the use of that particular vehicle, that is the drone, the insurance company with which the drone must be insured is liable to pay in case of any accident that occurs because of the drone which has been insured with the insurance company, your lordships. Where various courts have consistently adopted beneficial construction in such situations, your lordships, and held that the expression use of a particular technology in section 110 of the Motor Vehicles Act should be given a wide interpretation. And since there was the only human intervention that was required was during loading and unloading, it can be reasonably inferred that the accident also took place because of some glitch in the loading and unloading process of the drones itself. Your Lordships, now that I have claimed that the drones must be insured and the insurance company is liable to pay, for an arguendo, if we only assume that the owner of the drones did not get his drones insured, although it is mentioned that he got the necessary certifications, but even if we assume for the sake of an arguendo that he did not get his drones insured, he himself is liable to pay for the compensation in that case, Your Lordship. Chapter 11, sections 145 to 164 of the Motor Vehicles Act 1988 provide for compulsory third-party insurance, which is required to be taken by every vehicle owner, Your Lordships. To use this vehicle without the requisite third-party insurance being in force is a penal offense, firstly, Your Lordships. The right of the victim of a road accident to claim compensation is a statutory one, Your Lordship. The Parliament, in its wisdom, inserted the relevant provisions of the Motor Vehicles Act that I just mentioned to protect the victims of road accidents traveling in vehicle or using the road, thereby making it obligatory that no motor vehicle shall be used unless the vehicle is compulsorily insured against the third party risk. And in case an accident takes place and a motor vehicle was found not insured, the owner of the motor vehicle is definitely liable to pay for compensation. So Cutting Edge Technologies Private Limited, in this case, Your Lordships, did not get their drones in case it did not get their drones insured for the third party risks, then the company is liable to pay for the compensation to the legal representatives of Sushri Karishma Devi and Shri Chatur Kumar directly, Your Lordships. After that,
Mr. Arkash, I have a question, if you may. You're applying the provisions of Motor Vehicle Act to the drones. How would that be possible?
Sure, Your Lordships. Firstly, with respect to drones also, there are specific provisions of the Motor Vehicles Act, which the Motor Vehicles Act itself makes a choice to include the
provision, and specifically related to insurance.
Specifically related to insurance, I'm dealing with chapter 10 of the Motor Vehicles Act, Your Lordship, section 167 and 168.
I repeat my question. You are applying the provisions of Motor Vehicle Act to the drones. How are you doing that?
Sir, we are firstly dealing with the fact that the issue in debate at this point of time is the indemnification and the payment of compensation in case a in case an accident takes place with respect to a drone.
Let me rephrase my question. There is a distinction between drones and motor vehicles, or are you suggesting that drones are as good as motor vehicles? If not, then you have to have a link where the drones are allowed to be treated as motor vehicle by a law. I'm asking for where is the law?
Your Lordships, I am coming to that. Your Lordships, since we are debating on the part of insurance and since we are debating on the part of compensation, with respect to the drone rules, the rules for commercial drones 2016, which the provision is pari materia to the draft drone rules of 2021, the rule number 28 specifically, the part 10 of the drone rules deals with insurance. Now I'm dealing with drone rules, Your Lordships. The section
number 28 then in that case.
Pardon, Your Lordship, could you please repeat?
You're saying it's rule number 28 of the drone rules, right?
Sure,
that's what you're suggesting. Please read it out for us.
Sure. I was coming to that, Your Lordship. I'm grateful to you for your query. Your Lordships, the rule number 28 states the provisions of the Motor Vehicles Act 1988 and the rules made thereunder shall apply mutatis mutandis to third-party insurance of drone and compensation in case of damage to life and or of property caused by such a drone. Now, Your Lordships, they have said that mutatis mutandis, the provisions of the Motor Vehicles Act shall apply in case of accidents by drones. I'm sorry, Your Lordship, you are muted, so you were not audible.
Are you reading rules of 2021 because that's the latest one? Are you reading 2016?
Yes, Your Lordships, I am reading exactly that.
2021 rules?
the drone rules 2021, of which the rules for commercial drones 2016 in the state of Hastinapur are perimeteria, Your Lordship.
So section 28, the rule 28 of that
Sure, yes.
2021, what does it say? It's
Sir,
part
it
5, I
says,
believe, right?
could you please repeat, Your Lordship?
Because the rule that I have in front of me, it says carriage of dangerous goods, rule 28.
Your Lordship, I would seek pardon from you, but the drone rules, official drone rules, the draft drone rules of 2021, of which the legislation that we have, the rules for commercial drones 2016 is perimeteria.
They have been notified, sir.
Cannot be
They have
notified.
been, they have, sir.
Been notified, if I'm not mistaken, on 25 August 2021. There are no more draft.
Sure, Your Lordship, I have taken that into due consideration, but in the Moot proposition, Your Lordship, it has been mentioned that the provisions of the applicable act in the state of Hastinapur are perimeteria to the draft drone rules of 2021, Your Lordship. So we are referring to the draft drone rules of 2021 with respect to anything else. Because the perimeteria
draft is not a law.
Okay.
Please see the notification dated 25 August 2021. Draft
Sir,
is not a law.
Sir, my speaker 2 of my team has screen shared and has shared the applicable provision rule number 28. And regarding Your Lordship's query that the draft is not rule, sir, the rule in the state of Hastinapur that we are dealing this case in, it is the rules for commercial drones 2016, which is a full-fledged legislation. But the content of the legislation is perimeteria to the draft drone rules in India of 2021. So this is the content that 2016 adopted legislation in the state of Hastinapur contains, Your Lordship. That is why I am referring to the section 28 of the said provision.
What you should have referred to is not rule 44 of the 2021, because that means you did not, your research is not complete. The rules have been,
yes.
All the laws are perimeteria.
Sure, Your Lordship. But then I seek apology on that ground. But the content of the section, no matter the number, sir, the content is what I would like to. Sure, Your Lordship. If I've been able to satisfy
may I say something?
Please,
Now,
Your Lordship.
I believe that this moot court is proceeding on the basis of certain assumed propositions. And therefore, we are on the question as to how the lawyer is representing or presenting his case. We are not on the question of merit of the law proposition or merit of the law as it is, because it is said that this we are taking it that the Hastinapur laws are perimeteria same with the Indian laws, and on that proposition they are proposition that this is the law. Because the rule 28 shows that the insurance will be governed by the proposition of Motor Vehicles Act. Therefore, he is suggesting and he is submitting that it is that it will be governed by the Motor Vehicles Act. Let us hear him as to how he represents his case. Let us not go to the merits, because they are not prepared lawyers. They are budding lawyers. They are still students. Therefore, they must be given that benefit. We may not interrupt them so much. Let them press their case, and let us see only how they are placing their case and how they are arguing it. We will decide on the basis of his argument, not on the merit of this the proposition or anything else. We will go by the way they are presenting their case, that how well they are arguing it. Maybe we may not agree with the proposition, we may not, maybe law is wrong, whatever it is, but we must see that how they represent their case and how they argue it.
Okay,
that's the ability to argue. We will judge by that. Yes,
I'm grateful. I'm grateful to Your Lordship from the bottom of my heart for reiterating that. Now, Your Lordship, in the last part, just
one thing. Sorry for interruption. I must say that you have met our confrontation well.
Thank you. Thanks a lot, sir. I'm grateful to you.
That's a good sign of a good lawyer.
Please carry on.
Thanks a lot.
Yes,
now, just to move to the last part of this very contention, Your Lordship, I shall hereby like to iterate the contents of section 13 of the Employees Compensation Act.
Yes.
Which says that remedies of employer against a stranger is the heading of it. Now, where an employee has recovered compensation in respect of any injury caused under circumstances creating a legal liability of some person other than the person by whom the compensation was to be paid, or to pay damages in respect thereof, the person by whom the compensation was paid and the person who has been called on to indemnify under section 12 shall be entitled to be indemnified by the person who is so liable to pay damages aforestated, your lordships. Now, this section completely makes it clear that a stranger can also indemnify with respect to the loss that has incurred and the liability of the employer arises, but the fault was that of a stranger, so the indemnification can be sought from a stranger as well. This section also reiterates what I have just argued till now. Your lordships, with that I conclude the second limb of my arguments. Now I shall proceed on to issue number 3, your lordships, regarding the constitutional validity of the rules for commercial drones 2016. If you allow me, I shall proceed with my arguments.
Yes, yes, yes.
I'm obliged to you, your lordships. Now, issue number 3 of my contentions herein is pertaining to the fact that the rules of commercial drones 2016 are unconstitutional, your lordships, as they encroach upon the very fundamental right of freedom of trade under Article 19 of the Constitution of India. Now, when we assess a law with respect to Article 19, all the subordinate articles of the Constitution, which may not be included in the fundamental right, but also support the cause of Article 19, have also to be taken into due consideration in order to assess a law with respect to constitutional validity. Now, firstly, I shall deal with the issue with respect to Article 301 of the Constitution of India. Therefore, it is differentially submitted that Article 301 of the Constitution of Hastinapur, read along with Article 19, provides that trade, commerce, and intercourse throughout the territory of Hastinapur shall be free, your lordships. Now, this article imposes a limitation upon the exercise of legislative power, where the union or a state cannot legislate arbitrarily with respect to the legal provisions that are dealing with the freedom of trade in any part or any territory of the country, your lordship. The object of freedom declared under Article 19 is to ensure that economic unity of Hastinapur may not be broken by internal barriers, your lordship. The same internal barriers that the drone rules 2016 very effectively create, your lordship. No restrictions on rights provided by Article 301 or Article 19 in that case can be imposed by an executive action, your lordship. These freedoms can only be subjected to restrictions by Parliament under Article 302 and 303 or the state legislature, your lordships. Now, in the instant case, linking it to the facts of the instant case, Union government has violated Article 301 by restricting freedom of trade by drafting the rules for commercial drones, which regulate, in fact, restrict the operation of drones in various areas, and the power to make those areas specific has also been granted arbitrarily to the Ministry of Civil Aviation, your lordships, under the drone rules. In fact, the power is arbitrary and excessive. Pertains to the fact that no specific provisions in the drone rules are mentioned with respect to what are the areas, what is the sensitivity in the areas that makes the areas included in red zone. In fact, the areas that have been included only based on the fact that the central government wants them to be included in red zones, your lordships. So there is arbitrariness on the part of the government.
Mr. Akash, you are arguing Article 301 of the Constitution also, I believe, right?
Sure, your
Could you
lordship.
please tell me which law or which case law suggests that exercise of power under Article 246, Parliament need not be arbitrary while making a law if it is encroaching upon not a fundamental right but under Article 301?
Sir, I have included Article 301 just to reiterate the constitutional provision. It is indeed encroaching upon Article 19 as well, and I shall be dealing with Article 19 specifically hereafter. So I shall prove that Article 19 along with Article 301 both have been violated. So that is why it encroaches and has to be declared unconstitutional, your lordship, not only on the basis of Article 301.
So exactly my test is that if lawmaking power under Article 246, whereas lawmaking power under Article 19F, I believe for this for this one, would be different because the reasonable restriction is not required for Article 301, right? That law is made under Article 246. Read with 248. in the in the seventh schedule. That's what I'm arguing. Are you finding the curb on the parliamentary legislative power in form of arbitrariness and something which is not violative of fundamental right?
Sir, there are, with due respect, sir, there are two pleas that I have taken at this moment. One is with regard to arbitrariness and excessive power to the central government. And second is with regard to the encroachment of the rights of the people of this country under Article 19, that is freedom of trade, and Article 301 of the Constitution. Now, by the end of this argument, I shall hereby claim before the Honorable Court that even if we considered both of them simultaneously, that is the arbitrariness that the rules contain, and the power to the central government is unlimited and encroaches upon the right to freedom of speech, freedom
Which
of trade.
law in the
That is
Constitution
when I
says
say
that Parliament should not make arbitrary law?
Sir, if I'm right in saying this, it is Article 246 of the Constitution.
Read Article 246 in that case.
Sure, Your
Two
Lordship.
things are different.
Just give me 10 seconds.
Two things are different. Young man,
Then I may
two
seek
things are different.
apology from Your Lordships in that regard. But what I
Don't be afraid. We are just trying to see your mooting skills, as your Lordship has said. Since research is a part of your tasting, that's what I'm doing. So don't be scared. You are doing wonderful. We are very happy, more than happy about your performance.
Sure, Your Lordship, and I seek apology in that regard. What I seek to claim before the Honorable Court, I shall reiterate the fact with respect to arbitrariness, along with respect to the encroachment of freedom of trade, both of them to be used simultaneously as my argument. I shall hereby conclude my argument by saying that on various grounds, the rules of commercial drones have to be declared unconstitutional. So if I could complete all the elements due to which I claim that the rules of commercial drones are unconstitutional and conclude my issue, then if I could address the queries of the court, Your Lordship. Because I hereby shall deal with specific rules.
You can answer it later. Please go ahead.
Sure, Your Lordship.
Yes.
Sure, Your Lordship. I'm grateful to you, Your Lordship. Now I shall do it. If there is a query, Your Lordship.
I have a query. I want to understand the clarity between the two. On one hand, the Rule 28 of the Rules Act 2021, that is Commercial Rules 2016. That was never cited before.
I'm sorry, sir. Of 2021, it is Rule 44.
Right.
28 was for the draft.
That's all right. But it was never cited before the Honorable High Court, and you wanted to have advantage of that, telling that it is mutatis mutandis to the Motor Vehicle Act.
Students will not know that because they don't have the High Court decision. They do not know what was argued before the High Court. So that is not their fault. That's a moot problem. It's a moot problem that they have.
That's all right. And on the other hand, you wish to have this unconstitutional as well. So what is the interconnection between the two? You are taking shelter of this rule, and again you are citing that it is unconstitutional. So actually, what is your contention? I want to question.
Sure, Your Lordship. I am grateful to you for your contention, Your Lordship. Now, Your Lordship, I would first like to iterate the fact that the two issues are two separate issues to be assessed by the court. So under issue number 2 that has been framed by the Honorable Court, it was an argument with respect to the provisions of the Act and with respect to the compensation to be paid. Now, since in issue number 3, the court has also asked me to argue regarding the constitutionality, I have presented before the Honorable Court my humble opinion regarding how the provisions are unconstitutional, Your Lordship. But since it is the law of the land, because in 2016 the rules for commercial drones have already been legislated, that is why it is my duty to comply with the rules until the rules have been declared unconstitutional. And since I am debating the unconstitutionality, it is upon the intelligence of the Honorable Court to declare them unconstitutional post my argument, Your Lordships. But until then I'll have to comply with the provisions of the rules, Your Lordships.
Please, correct.
If I've been able to satisfy the court, can I please proceed further? Now, I shall, your lordships, deal with the specifics of the drone rules that I feel make the legislation, the draft drone rules unconstitutional, your lordships. Now, there is rule number 35 of the rules for commercial drones, which gives arbitrary power to central government to revoke any license, certificate, authorization, or approval granted under the drone rules itself. This add a factor of uncertainty, your lordships, because it has not been specifically mentioned on what grounds the license can be revoked at any point of time. Moreover, sir, the rule number 35 also makes it compulsory for people to adhere to the provisions of the Act with respect to the fact that the operation of drones has to be construed with respect to the map that has been issued under the drone rules, and the zones that have been declared red zones. People are not permitted to fly drones in that specific in those specific areas that have been mentioned as red zones, your lordship. Now, that provision with regard to red zones, had they specified that we will declare red zones only those areas that are in cantonment areas or that have privacy issues or that have security issues, we would have complied with the rules, your lordships. But it is as arbitrary as saying that the central government has at any given point the power to issue a notification as to what may be construed as a red zone with respect to the drone rules. And thereafter, your lordships, after having declared something as a red zone, people are not allowed to fly drones or carry out any trade in that particular area that has been declared a red zone. Now, which is excessive and arbitrary on the part of central government, your lordship. In addition to that, your lordships, the restrictions imposed under Article 19(1)(g) and Article 301 read simultaneously are subject to those restrictions which are reasonable and not arbitrary or excessive in any manner, your lordship. Now, linking it to the present case, the central government has imposed an unreasonable, arbitrary, and excessive restriction upon the freedom of trade through the rules of commercial drones, as direct and immediate restrictions have been imposed on the trade and business by drones, by not only regulating but restricting the flight of drones just by virtue of a central government's time-to-time notification, your lordships. So, if they were not that arbitrary, and if they were specific about how we would go about the operation of drones in the country, and they had made those specific regulations compliant to the reasonable restrictions under Article 19(g) of the Constitution, we won't have come to your court to argue the unconstitutionality of this rule. But because, your lordships, these rules are arbitrary in nature because no specific provisions have been made, that is why we argue that they are unconstitutional. Moreover, your lordships, coming back to what your lordship had a query about with regard to the fact that whether they are draft drone rules or they are drone rules of 2021, your lordships, since we are admitting the fact that they are draft, indeed the Moot proposition mentions them as draft drone rules of 2021. Having read about the draft drone rules, sir, I would like to mention that the draft drone rules were published for the intelligentsia and the academia also to make their viable suggestions with regard to how the government should go about finally framing them, your lordships. Now, when the arbitrary and excessive power has been granted to the central government, your lordships, in the situation that we are dealing the Moot proposition in, the drone rules, draft drone rules have the rules for commercial drones, your lordships, is a legislation of 2016. And we are dealing with 2022, and the legislation is peri materia to the draft rules of 2022, and that is why we seek arbitrariness on the part of the government, because since the powers incorporated in those draft rules, the powers given to the central government under those rules is so arbitrary that the impugned legislation has to be declared unconstitutional right now, unless it is otherwise it is restrictive of the freedom of trade in the said proposition, your lordships.
Rakesh,
Now, your lordships,
1 minute. You have been consistently using the words excessive and arbitrativeness on the part of the central government as far as notifying draft commercial drone rules are concerned. Now tell me, what makes you think repeatedly saying that it is excessive and restrictive in nature? Don't you think in order to save public life and human life, some restrictions have to be given some rights have to be given to the central government. Certain powers have to be given to the central government. Of course, those powers and those restrictions and cappings have to be judicially explained and used and to be incorporated suitably wherever warranted for the welfare of the society in general. But what makes you think that it is excessive and restrictive? Otherwise, in every gully and in every place, you will find commercial drones doing the commercial business, and people's life getting hit and hampered, and they loss of life or maybe accident because of excessive, unrestricted use of commercial drones for commercial activities. Don't you think so? How do you react to that?
Sure, Your Lordship. Thank you for the query. Sir, with due respect to what you have just mentioned in your query, Your Lordship, we are indeed in the favor of regulating the operation of drones in the country in a specified manner. Every legislation of this country regulates the fundamental rights of citizens in a manner more than one, Your Lordship. So the Motor Vehicles Act is also a legislation that restricts some movement of vehicles. Every legislation does that, Your Lordship. So should the drone rules, and the drone rules should make it specific that what is the reason as to why you have the power. If you do have the power, what is the reason as to why you do have the power? Now, Your Lordship have mentioned the fact of national security or security of the citizens, Your Lordship. In fact, I would like to reiterate the fact that no specific provision has been made in the drone rules that, considering public safety in mind, what is the specifics of the drone rules that we restrict the area of drones in some areas because of. Had they specifically mentioned that, okay, you are not allowed to fly drones in cantonment areas, okay, you are not allowed to fly drones in highly dense residential areas, okay, you are not allowed to fly drones in so and so
Mr.
areas,
Arkash,
we would have complied to the.
Mr. Arkash.
May I suggest one thing? May I suggest one thing? That look
Yes,
here, we
yes,
have
those
some time
questions.
constraint. I believe we have some time constraint. We cannot go on with this for a longer time because the other speakers are waiting. Number one. Number two, we are not supposed to write a judgment on his argument. Therefore, we are not going to merit of this case, but we are only to see that this is a moot court.
With
It's only his capacity to argue, not to test his test the validity of the argument. And even a lawyer has to make submission which is invalid and we overrule it. That's a different thing. Let him say which is not we can overrule it, but let him argue it and conclude it. We may not interfere with this merit of the submissions. Let us not interfere with the merit of the submission. We must see that how good they present your case. Present their case.
I agree with your lordship. However, there are few research questions that must be asked, but I agree with you largely, your lordship.
No, that is, I believe in moot court we are not supposed to so much put so much questions to them because it's only a moot court. It's not a court. In court we can do that because we have to write a judgment. Here we are not going to write a judgment. Here only we have to judge how good they have argued. Therefore, let us, and there is also time constraint. Let us not argue.
Let's go ahead.
Let us be a little moderate.
All right.
All right. Very true.
All right. Please conclude your submission.
Please go ahead.
I'm grateful to your lordships. If I could just conclude the contention that your lordship made in one sentence, and then I could move to my prayer, your lordship.
Please don't repeat. You have repeated your argument also 2-3 times. Please don't repeat. You conclude your submission.
Sure, your lordships. Just in completion of that very argument that I was making. So if they had made specific provisions in the drone rules, we would have complied to the drone rules and we won't have fought for unconstitutionality, your lordship. Since no specific provisions have been provided in the drone rules, it has only been mentioned that the government may from time to time notify. That is what I claim as arbitrary and excessive. Now, if I could move to the prayer, your lordships.
Yes, thank you.
So I'd like to solicit permission for reciting the prayer before the Honorable Court.
All right.
Sure, I'm grateful to your lordships. Wherefore, in light of issues raised, arguments advanced, and authorities cited, it is humbly prayed that this Honorable Court may be pleased to, number one, allow the appeals filed by RAPS Private Limited. Number two, declare the government notification dated 1st of January 2016 under the Employees Compensation Act 1923 does not apply to accidents that took place before the passing of the Gazette notification. Number 3, set aside the order of the Honorable High Court of Andhra Pradesh that doubled the amount of award to the legal representatives of Shri Apar Shakti. Number 4, declare that the claims under Employees Compensation Act 1923 and the rules for commercial drones are not mutually exclusive. And number 5, hold that Cutting Edge Technology Private Limited is liable to indemnify RAPS Private Limited for the payment of compensation to the legal representatives of Sushri Karishma Devi and Sri Chatur Kumar, and pass any order, direction or relief that the Honorable Court may deem fit. With that, the counsels for appellant rest their case. It was an honor arguing before the honorable bench. Thank you. Thank you, Your Lordships.
Thank you. Thank you so
All right.
much.
Thank you very much. Yes. Let us hear the other speakers.
Your Lordship, before we proceed for the respondents, I just wanted to confirm whether you received the compendium for the respondents.
We have.
Go ahead.
Yes, we have.
Much obliged, Your Lordship.
Yes.
Good afternoon, Your Lordships. If all clarifications have been made, I request your permission to stay unmuted and address Your Honor, Your Lordships.
Yes.
Indeed. May I confirm if I am visible and
Yes, you are.
audible at the same time?
Both you are visible as well as audible. Please continue. Carry
Indeed, Your Honors. Just to clarify preliminarily, because I'm not able to see all of Your Lordships and at the same time on the screen, you may interrupt me at any point of time if there is a question in regard to my submissions, Your Honor. Your Lordships?
All right, carry on. Please carry on.
Indeed, Your Lordships. Indeed. Indeed. Your Lordships, I am counsel number 1 for the respondents, representing respondent 2, Cutting Edge Technology Limited. In the present case, I shall be addressing this court for a duration of 20 minutes on issue 2 on the question before this court, whether the Employees Compensation Act and the drones rules are mutually exclusive. And my co-counsel shall be addressing this court for a duration of 23 minutes on the issues 1 and issue 3. We reserve 2 minutes of our time for rebuttal. Your Lordships, I now seek your permission to briefly address and recap some of the facts of the case only with regard to issue 2. Your Lordships, on the 16th of January 2018, while goods were being loaded to the drone system, it developed a malfunction and could not hold the weight being attached to it. It fell on the heads of 2 RAPS employees, Karishma Devi and Chatur Kumar, leading to their death on the spot. Their legal representatives filed for compensation under the Employees Compensation Act, which was approved by the Deputy Commissioner. RAPS Private Limited in turn asked Cutting Edge Technologies to indemnify them for the compensation awarded to the families of the deceased employees. RAPS Private Limited sought to be indemnified for the same. However, the High Court of Andhra Pradesh dismissed their claim. Upon filing a special leave petition to the Supreme Court of Hastinapur, the Supreme Court was seized to decide upon the specific issue, and I quote, whether the Employees Compensation Act and the Drones Rules 2016 are mutually exclusive. Your Lordships, it is our contention that in the said case, the Employees Compensation Act does not place any liability upon Cutting Edge and any such, and as such, the elements of the drone rules cannot be imported to decide the indemnification under the Employees Compensation Act. Your Lordships, we argue this on 2 fundamental grounds. Namely, first one, the Employees Compensation Act does not itself place any liability on the respondent, and 2, the draft drone rules and the Employees Compensation Act are mutually exclusive. Once the doctrine of election has been utilized through the Employees Compensation Act, further application of the drones rules would not be sanctioned. On the first ground, Your Honors, Your Lordships, I apologize on that matter. On the first ground, the council places before this court section 12, or for that matter, section 13, that is emphasized by the petitioners. And we place that these sections do not purport liability on Cutting Edge directly. Your Lordships, section 12 of the Act does not apply in the present instance, since a bare perusal of section 12 indicates that the cornerstone of application of section 12 is the existence of some form of contractual relationship between the contracting company and the employee. While such an employer-employee relationship existed between RAPS Private Limited and the deceased employees upon whose heads the drone fell upon, there existed no such relationship between cutting-edge technology and the deceased. Your lordships, if your lordships are in view of section 12 at the present moment, I may further emphasize that the fundamental principle as such, as further also laid down in the in supporting judgments such as G. Sridharan versus Hindustan Ideal Insurance Corporation, is that for such an application, there must exist a contract between the principal, the contractor, and the employee. Here, while RAPS Private Limited and the deceased have contracts for employment, Cutting Edge is a third party in the present instance. However, let us for a second assume that they are a third party, and what of such a compensation, and should they be liable in the present instance. For this, I direct the attention of your lordships to section 13 of the Employees Compensation Act. Your lordships, section 13, which applies to strangers, is also not applicable in the present case on the first bare perusal, and further supported in light of the decision in the case Kerala State Electricity Board versus Sundaram Estate. Section 13 grants the power to an employer beyond fixed contracts for work and agreements containing clauses of indemnification to move against any such stranger or person who has a tortfeasor is instantly liable for the injury caused to the employee. However, such a liability does not immediately is not immediately present upon Cutting Edge. Why so? Your lordships may ask. Your lordships, as your lordships may see from paragraphs 7, 8, and further supported by paragraph 15, Cutting Edge merely took care of the drones in rare instances, and the actual control of the drone was with the drone itself. It was automatic in nature, and it did not need any regulation. Further, in terms of the question of due diligence, it is very clear, if the court were to ask whether or not Cutting Edge is a tortfeasor in the present instance, the council would like to present that the Cutting Edge technology had done due diligence, as your lordships may see from a perusal of para 7 of the undisputed facts in the present instance. They had conducted various trials, and they had tested the drones for that matter. And in light of the same, they had conducted their due diligence, and for that matter, they are not a tortfeasor. Now, let us for a second assume the arguments that is raised by the petitioners in this matter regarding the mutual, non-mutual exclusivity of the drone rules and the Employees Compensation Act to place some liability upon the upon Cutting Edge. Let me take, because there has been some confusion on the matter regarding which one of the drone rules has been applied in the present instance, I shall take upon myself the liability of the more potent rules, which is the draft ones, even though we do agree that Rule 44 is the one with regard to the new rules. Let me take upon myself the highest case of the petitioners with regard to the same and argue before your lordships with regard to whether or not they can be mutually exclusive or not, and whether the interpretation of the drone rules read through the Motor Vehicles Act can be imported into the Employees Compensation Act while deciding a case, after, especially after the doctrine of election has been decided. Your lordships, the council would like to draw your attention in this regard to section 19 of the Employees Compensation Act, which clarifies that the powers of the commissioner appointed as per the Employees Compensation Act are limited to the matters under the Act. Further elaboration on the powers of the commissioner under the Employees Compensation Act is seen in the case of Charad Chemical Industries versus R.G. Ganeshan, a case that has been presented in the compendium to your honors, wherein the Madras High Court elaborated in paragraph 11 that it would be a misconstruction of section 19 to allow the person to plead liability that is not present under the Act to the commissioner. In that case, what had happened was the insurer said he had no liability whatsoever in the Employees Compensation Act, but had liability under the Motor Vehicles Act. The question before the court was, can the commissioner in the present instance decide upon a matter within the Motor Vehicles Act? The court held otherwise, and the court said any violation of this principle of deciding within the Act would be a violation of the principles of the administrative law, specifically the doctrine of substantive ultra vires, as further elaborated by the decision of this court in the landmark case of Ajay Kumar Banerjee versus Union of India, which elaborated on the elements of the doctrine of ultra vires. Further on this point, if your lordships may indulge the council, I would like to present two decisions of the Kerala High Court and the Madhya Pradesh High Court, shedding light on the present matter. And before I go on in terms of the judgments of this court, an important facet that is needed to be clarified is, assuming all things said and done, and even if mutual exclusivity is avoided, and there is a harmonious construction that is provided to the said acts, the liability that is placed through the Motor Vehicles Act is upon the owner of the said the drones, for that matter, or the owner of the vehicle. In light of the same, I draw the attention of your honors to the undisputed facts of the proposition, specifically paragraph 8 and paragraph 15. Paragraph 8 clearly points out that there has been a contract between RAPS Private Limited and Cutting Edge Technology for the delivery of said drones. What is the nature of this contract is later clarified through paragraph 15 of the proposition, which further emphasizes that it was a purchase agreement. Once it is the purchase agreement, then the ownership has now been handed over to who? RAPS Private Limited. So the owners themselves, who have a liability under the Motor Vehicles Act, are coming before this court to seek indemnification from Cutting Edge. Let us for a second assume that Cutting Edge itself is the owner, and we shall take, let's say, our worst case in that manner, even though that is not supported by the facts of the circumstances. I would still argue on the matter, the theoretical aspect of law on this matter. And in light of the same, I would present the cases of the Kerala division bench of the Kerala High Court and the Madhya Pradesh High Court to your lordships' kind consideration. Your lordships, if you may refer the case of United India Insurance versus Joseph Mariam, a division bench of the Kerala High Court emphasized that when a liability does not exist under the Employees Compensation Act directly, then the meaning of the Motor Vehicles Act cannot be imported to deliver such a meaning. And for the reasons, these are mutually exclusive in nature. So even if it is not mutually exclusive, there is no liability. That is, and in the right form of interpretation, it is actually mutually exclusive. This view is also supported by the decision of the Madhya Pradesh High Court, your lordships. And in light of the same, I draw the attention of your lordships to the case of National Insurance versus Jabundi, where the two said acts were held to be mutually exclusive of each other with regard to the liability of the persons specifically. And that was also a similar case where the insurer had said he had no liability under the Employees Compensation Act. His liabilities only arose under the Motor Vehicles Act. And the court held, yes, you are right. Your liabilities only arise there. And therefore, under the Employees Compensation Act, you are not liable. In light of the same, your lordships, I would like to specifically emphasize that once the doctrine of election is utilized, that the right has been particularly used before one forum. And this is specifically, the doctrine of election is particularly important in terms of the contention that is made with regard to section 167 of the Motor Vehicles Act that the petitioners bring forth before this court. Section 167 does say that any right to claim before the motor vehicles tribunals or any other court with regard to the Motor Vehicles Act is does not prejudice the rights of such a person under any other law in force, especially the Workmen's Compensation Act. What the accurate interpretation on this matter is, and the various courts, which is the division bench of the Kerala High Court and the Madhya Pradesh High Court have emphasized, and they've clarified the point that what 167 clearly tries to do is forbid dual remedies in that matter. And therefore, this is something that we agreed to, that dual remedies are in fact not something that can occur within the Act, and therefore dual remedies should not be allowed. But what our contestation is a harmonious construction of the Employees Compensation Act and the Motor Vehicles Act cannot exist at the same time. In light of the same, we have presented the various cases of national insurance and also United India Insurance, your lordships. Further, there exists a contention with regard to the insurance corporation and how because the person who has registered the drones, who is also liable to make the make an insurance for that such a drone. Let us for a second assume that RAPS Private Limited is not the owner. They are actually the owners, but let's for a second, for the best case of the petitioners, assume that RAPS Private Limited is not the owners, but in fact Cutting Edge is the owners. In light of the same, to place the insurer liable in the present instance, there has been ample jurisprudence on this court, and I believe the judges on this court would greatly support me, especially those who have served in the trial courts, that the insurer must be presently a party to the case. The liability of putting the insurer as a party to the case necessarily is upon RAPS Private Limited themselves, and they have not effectively exercised the same. Therefore, your lordships, I would like to effectively summarize my argument by saying that when the employee himself, as through the doctrine of election, which allows that when two rights are present before two tribunals, he may opt for one, and he has opted for one of election, then such a doctrine must be pushed forward in such a manner. In this case, he has opted for remedies under the Employees Compensation Act. Your lordships.
Okay, all right.
Indeed, your lordship.
Let's move to the next one.
Indeed, your lordships. In light of the same, I would like to conclude my submissions, especially succinctly in terms of the fact that Section 12 does not place a liability. Section 13 also does not place a liability because due diligence has been handled and the drones operate by themselves. Then Section 19 clarifies the role of the commissioner and to the extent to which he can make decisions, the jurisprudence of the court in that manner. Then further assuming that the Motor Vehicles Act, if it were to be read harmoniously, that only the owner would be held liable. In the present case, Cutting Edge Technology is not the owner because they have made the sale. And in light of the same, further moving on, there is also making the assumption that with regard to the doctrine of election, we have also established that the employee has exercised his right, and therefore the court must align itself with respect to a non-harmonious construction and hold that the acts are mutually exclusive in nature. That concludes my submission with regard to issue 2. I am open to any and all questions that is to be raised by your lordships, and if not, I heed my time to my co-counsel.
I have no query.
I also have no query. Let's move.
I have no query.
So we may proceed.
Indeed, Your Honor.
You have concluded.
Indeed, Your Honor.
You have concluded.
Yes, it was an honor to argue before this esteemed
right,
bench.
you have done very well. All right, you have done very well. Let us hear the next speaker.
Greetings, your lordships. Merely confirming if I'm audible and visible before proceeding.
Yes. Your name, please?
My name is Joel, your lordship.
Yes,
Joel.
Joel. Yes. All right, carry on. You are for the respondent.
Indeed, your lordship. Your lordships, I appear as counsel number 2 on behalf of the respondents in the present matter. The council presents 2 submissions before this honorable court. Firstly, that the government notification dated 1st of January 2016 should be held to be applicable to accidents which took place prior to the notification. And secondly, that the rules for commercial drones 2016 are constitutionally sound. With regard to the very first submission before this honorable court, it is important to note, Your Lordships, that issue number 1 pertains to the legal dependence of Sri Apar Shakti attempting to seek compensation in light of his untimely demise due to the accident that had taken place in 2014. It is most humbly submitted that when interpreting the quantum of compensation that is to be payable, it would be in the interest of justice that the interpretation be one wherein the notification dated 1st of January 2016 should be applied retrospectively in the present matter, and the council would be making submissions supporting this particular claim. Your Lordships, considering the question of limitation has arisen, particularly by my learned co-counsels for the appearing on behalf of the petitioners, the council would like to make a few submissions with regard to why limitation should not be considered a bar in this present matter, considering that limitation, the delay that is involved can be condoned in this particular case. In several cases, either the judiciary itself or the deputy commissioner has applied their discretion to condone the delay which may arise, considering that the object of the act is to provide for the welfare of people applying for compensation under it. One such instance can be noted in the case of Mahesh Bhai Belani versus Suleiman Duda, a 2014 judgment, wherein the Gujarat High Court had condoned the delay with regard to a claim that was made under the Employees Compensation Act. Additionally, Your Lordship, the Council would also like to place reliance on Section 10 of the Employees Compensation Act 1923. Your Lordship, Section 10, Clause 1B in the proviso to the statute notes that the Commissioner may entertain and decide any claim to compensation in any case, notwithstanding that notice has not been given or the claim has not been preferred in due time as provided in the subsection, if he is satisfied that the failure to give notice or prefer the claim, as the case may be, is due to sufficient cause. In the facts of the present case before this honorable bench, Your Lordship, it is to be noted that the claim, although did arise on 10th April 2018, the Deputy Commissioner has not dismissed the claim for the delay that is involved. In fact, the Deputy Commissioner has applied their jurisdiction, their discretion in allowing the matter and has, as is elaborated by paragraph 11 of the Moot Court proposition. Additionally, relying on this very court's jurisprudence that has developed, in the case of Craft Center versus Concherry Coir Factories, it was held that generally it is the duty of courts to dismiss the suit if there is a delay that is involved. However, in this present case, although there is a delay, the court has elected to allow for the suit, which means that the discretion of the court is being applied in a manner that allows for an equitable treatment of the parties involved, considering that they are considering that they are employees, they are beneficiaries under the primary legislation of the Employees Compensation Act, and therefore any delay which has arisen should be condoned in the interest of justice, Your Lordship. If Your Lordships do not have any preliminary inquiries with regard to the submissions made with respect to condoning the delay in filing of the application, the Council would proceed to make submissions with regard to the retrospective application of the same.
Please proceed.
Much obliged, Your Lordship.
Do you want to add anything? But because your other counterpart had argued that each day's delay has to be explained and they are
explained.
Indeed,
what do you say about that?
I guess he has argued Section 10 by saying that the Commissioner has power. That's what his argument is to that.
Indeed, Your Lordship, Section 10 is particularly applicable in this case because the Commissioner has already elected to allow for the claim amount and has applied his discretion, considering that the legal dependents of Apar Shakti are applying for compensation. Therefore, the matter, as per paragraph 11 of the...
that is with regard to the notice given to the question of notice, not with regard to the delay in making the application. That is, he has the discussion with regard to the notice, that if no notice is given, he can elect, he can condone it, that without notice he can accept it. But what is about the question of what do you say about this delay, explanation of delay of each day's delay or sufficient explanation?
Much obliged, Your Lordship. On Your Lordship's question in this regard, we would refer particularly to the language of Section 10 clause 1B of the Employees Compensation Act, which provides that the
Yeah.
commissioner, if your lordship would prefer it, my learned researcher can share the same provision on the screen before this honorable court.
So you tell us.
Please tell us verbally also.
Indeed,
Yes.
the council will be reading out the same, provided further that the commissioner may entertain and decide any claim to compensation in any case, notwithstanding that notice has not been given or the claim has not been preferred in due time. Therefore, this particular provision, your lordship, considers both aspects of a notice being not given or also a claim being delayed before the commissioner. And in the interest of equity, the commissioner has entitled to apply the discretion to condone the delay and allow for the claim to be settled. And as per paragraph 11 of the facts of the case, the commissioner has applied discretion and has allowed a particular claim amount. The present dispute is about the quantum of that claim amount, which is to be decided before this honorable court.
All right.
Much obliged, your
No,
lordship.
but the issue of limitation and capping of 2 years is also an equally important issue, because there are a number of such like cases, as Moot court has discussed and argued both the parties. Before proceeding ahead on the amount of compensation, death compensation, fundamental and primary question of limitation also remains to be addressed. It's not left at the sole discretion of the commissioner. Of course, Act says so. If there is a delay of 2 years or 3 years, under the principle of equity, and given the powers of the discretionary to commissioner, if he decides and condones the delay, then what is the wrong in 4-year delay cases, 5 years delay, 10 years delay cases? Every such case, a human life is involved. Social justice is involved.
Indeed.
But there has to be some capping, which Act provides for 2 years, and very, very minute judicial examination to be conducted by Commissioner Compensation in allowing or in not allowing the condonation part of it. That is fundamentally very important before proceeding ahead on the quantum of the compensation.
But since this is the matter is before Supreme Court under Article 136, and the question has been framed and the limitation issue has not been raised.
Indeed.
And moreover, it will become a question of fact rather than the question of law, that what would be condoning, and given the limited facts which can be elaborated in a moot proposition, so the council will be in a very tough situation. And moreover, it's Article 136 question has been very exclusively put before the court, before the Supreme Court, Honorable Supreme Court. So I think that
very true. Very true, Dr. Abhishek.
Thanks, sir.
Indeed, your lordship, the council understands the concern with respect to the pendency and delay involved in such cases, but the other facts of the proposition remain silent as to the reasons why the deputy commissioner has accepted the same. And in light of the present facts, the council is merely making submissions in response to the counsel for the petitioner's claims that limitation has to be invoked in the present case, Your Honor. Your lordship, proceeding onwards, if your lordship permit the council, it is the submission.
All right. We proceed to the next point.
Indeed, your lordship. Your lordship, at the very outset, the council would, in the interest of justice, would like to clarify that the general approach that has been taken by the judiciary in this regard is one that is against the respondents in the present case, wherein the general approach has been to apply for that the amendment or notifications to the legislation was always applied prospectively in nature. And that is the position of law that is settled. And the council would like to place reliance on the case of Pratap Narayan Singh Dio versus Srinivas Dabata, a 1976 judgment of the Supreme Court, wherein a 4-judge bench had decided that an amendment to the 1923 Employees Compensation Act should be applicable prospectively and not retrospectively. And the same has been upheld in other cases, such as in the case of Kerala State Electricity Board versus Valsala, and even a 2021 recent Supreme Court decision in the case of K. Shivaraman versus P. Satish Kumar, wherein it was decided that the application should be under Pratap Narayan Singh Dio versus Srinivas Dabata, which is the leading case in this regard. Although this is the settled position of law that exists today, your lordships, it is still contended that the present case is before a constitutional bench of 5 judges, which can still reconsider this particular question of law and can make a judgment in as it. Your lordship, the council submits that particularly the case presently is before a 5-judge constitutional bench, And the same question of law can be reconsidered, thus overruling the precedent given in the 4-judge bench of the case of Pratap Narayan Singh Dio versus Srinivas. And the same is argued in light with the objective of considering that the interpretation of this particular act must be done following the legislative intent, and that would be the first submission in that regard, your lordships. As is shown on the screen before your lordships, particularly noted in the 2021 case of Shivaraman versus P. Satish Kumar, the 1923 Act, the Employees Compensation Act, is a social beneficial legislation, and the amendments should be interpreted in a manner so that the benefit to the employees is not denied. Furthermore, in the case of RMDC versus Union of India, the Supreme Court of India had stated that the statute is to be construed according to the intent of the legislature. That is, legislative intent, or the Latin phrase which is used, sententia legis, becomes a very important factor when interpreting the said provisions of law. The statement of objects and reasons of the Employees Compensation Act 1923 are clear, insofar as the objective of this law is to allow for the payment of compensation to employees for injuries that arise by accident. Furthermore, it is most humbly submitted that in the case of Juti Devi versus Pine Chemical Limited, and this becomes a very important case for this court to consider, it was noted that the authorities should not be expected to adopt a technical approach which is inconsistent with law with the objective of taking away benefit from the workmen. To reiterate this particular point, your lordships, the court has considered that a technical approach which takes away rights of the workmen should be deprioritized, and emphasis should be given on an approach which allows for the rights of the workmen, considering that the act is passed with the objective of conferring benefits and allowing for compensation to the workmen that are aggrieved during the course of employment. Applying these particular points of legislative intent in the present matter, your lordships, it is most humbly submitted that this becomes a fitting case to apply for a retrospective application, considering this would be an interpretation of harmonious construction between the legislative intent and the existing legislation or existing notification. Because if the notification is not applied retrospectively, a grave injustice is done to the legal dependents of Sri Apar Shakti who are seeking compensation not as profit but as a means of survival in light of their in light of their breadwinners' unexpected demise. In this regard, it is most humbly submitted that it is important that the interpretation that is carried out by this honorable court with respect to the retrospective application should be one that allows for the compensation to be granted, considering that that particular aspect is the legislative intent in the particular matter. And generally, the approach has been to allow for compensation, as has been shown on the screen before your lordships. Furthermore, in addition to the point with respect to the retrospective application, your lordships, the council would also like to direct this honorable court's attention towards the issue with respect to the obligation to pay on part of the petitioners has not been fulfilled. The obligation to pay the compensation, which is noted particularly in Section 4A of the Workmen's Compensation Act, is to be considered in this case, your lordship. Section 4A of the Compensation Act in clause 2 notes that in cases where the employer does not accept the liability for the compensation to the extent that is claimed, he shall be bound to make provisional payment based on the extent of liability which he accepts, and such a payment shall be deposited with the commissioner or made to the workman, as the case may be, without prejudice to the right of the workman to make any further claim. This particular provision of law is important to consider in this regard, considering that the claim amount is under dispute, as is explicitly provided for under this provision of law. And even if there is a dispute, the employer is still obligated to pay the compensation up to the quantum that is still accepted by the employer in a manner that allows for the employee to get some amount of money in regard to a disputed claim. However, the facts of the case are very clear insofar as the same has not happened, because there is no mention of a deposit being made to the commissioner, nor is a deposit of the agreed upon amount being made to the legal dependents of Sri Apar Shakti in this regard. Your lordships, with that, the council would like to conclude particularly on issue number 1, that despite the existing precedents on the matter, considering that this is a 5-judge constitutional bench which can overrule the precedent that was relied upon, and furthermore, it becomes a befitting case to apply the legislative intent And this is a growing trend, considering that in the case of K. Shivraman versus P. Satish Kumar, as this can be seen in the screen before your lordships, the court accepts, despite accepting that it is a social benefit legislation, it is said that the Pratap, it is simply bound by the category of law that was laid on in Pratap Narayan Singh and Valsala cases, because of them being larger benches. However, this court, being of a larger bench than the bench in the Pratap Narayan Singh, would be a befitting court to reconsider this position of law and consider that retrospective application of law would be completely in consonance with the legislative intent behind the law, which is to provide for benefit and to streamline the payment of compensation to aggrieved employees as well as their legal dependents.
Show us any court of the any decision of the Supreme Court where retrospective application of a executive notification or statute was allowed, so that we can, grant you the request you are making to us, or please.
Your lordship, although not a case explicitly in that regard, a three-pronged test was laid down in the case of if the council would be granted just a second to present the case before your lordships.
Please.
Indeed, your lordship. The council would like to place reliance particularly on the case of CIT versus Vatika Township, and this was a case wherein your lordships, in the case of CIT versus Vatika Township, the court did hold that when in certain cases retrospective application can be done, and that would be in line with the principles laid down by this court. And the same can be seen before your lordships on the screen at the moment, wherein the court said that when the legislation confers a benefit on some persons without inflicting a corresponding detriment on some other persons or the public generally, and where the conferral of such a benefit appears to be the intent of the legislature, the presumption of prospective application may stand displaced. Applying the rationale of this court in the facts of the present case, it is submitted that the first and third prong are undisputably satisfied because a benefit is being conferred, and the Employees Compensation Act does in fact seem to be of the opinion that the workmen should be getting the greater quantum of compensation. Although a dispute may arise with respect to the second prong, with regard to inflicting a new corresponding detriment, the council still submits that this is not the imposition of a new detriment that is being imposed.
That's all right. I'm more than satisfied. Please move to your next topic.
Much obliged, your lordship. If your lordships are so pleased with the arguments submitted henceforth with regard to issue number 1, the council would be pleased to move on to issue number 3, lest this court have any other questions for the council with regard to issue number 1.
No, it's all right.
Much obliged, your lordship. Your lordships, issue number 3 involves the petitioners challenging the constitutionality of the rules for commercial drones 2016, and in this case, the central government of Hastinapur has been adjoined as a respondent party in this case, as per the clarifications to the problem that were released, namely clarification number 2. In this case, the challenge of constitutionality should fall in favor of the respondents, particularly considering a two-pronged submission that is being made by the council for the respondents in this case, your lordships. Firstly, that the presumption of constitutionality stands in favor of the rules for commercial drones 2016, and secondly, that the rules for commercial drones 2016 merely make a reasonable restriction under Article 19, Clause 6 of the Constitution of Hastinapur. Your lordships, one of the cardinal principles of interpretation, as has been particularly noted in the case of K. Anaya versus K. Chandraya, a 1998 case of this Honorable Supreme Court, was that the cardinal principle of statutory construction is that the rule must be considered constitutionally valid unless a clear case of unconstitutionality is established in the regard. The premise upon which this principle of presumption of constitutionality rests is on the presumption that the legislature is able to know and appreciate the needs of the people in the region, and that is why the legislature is conferred with that kind of power to make legislations and bylaws to address issues in society. And the same was observed particularly in the case of PUCL versus Union of India, a 2000 case. In this regard, a presumption of constitutionality exists in favor of the statute, considering that the union government has come out with these particular rules particularly noting the problems that were caused for considering drones in the region. It is to be noted that just prior to the implementation of these rules, the usage of drones had in fact the usage of drones had in fact ended up with the deaths of two individuals that has been argued about with respect to issue number 2 as submitted by my learned co-counsel. This shows that the usage of drones, be it in businesses or in general, poses a threat when not done in an extremely cautious manner, which becomes a proper need to carry out a reasonable restriction over the same. Even if your lordships believe that the presumption stands awash, considering the submissions being made by the learned counsel for the petitioners, it is still submitted that in this particular case, the rules that are being made are completely in line with the principle of reasonable restrictions as laid down in Article 19, Clause 6 of the Constitution. Your lordships, Article 19, Clause 1G does in fact provide for the citizen's right to practice any profession or to carry on any occupation, trade, or business. However, that right comes with a corresponding restriction in the form of Article 19, Clause 6, which says that nothing in subclause G shall affect the operation of any existing law insofar as it imposes or prevents the state from making any law imposing, in the interests of the general public, reasonable restrictions on the exercise of the right conferred by such said clause. The particular phrase that is used in Article 19, Clause 6 is important to consider, your lordships, considering that the threshold is that there should be an interest or general interest of the society to be preserved. And that is the case with respect to the drones rules as well, wherein a reasonable restriction is being made on the operation of drones with regard to the interest of the general public. Your lordships, relying on the works of eminent jurists such as Sri D.D. Basu as well as Sri H.M. Sirvai on constitutional law, as they had noted, the phrase of interest of the general public refers to a comprehensive expression comprising of matters concerning public welfare, public health, order, safety, and so on. As such, it is well within the state's purview to create restrictions on the freedom of trade insofar as it feels that any of these aspects such as public health, public order, safety are being threatened in some way or another, and such restrictions cannot be called unreasonable for the same. In this regard, it is submitted that the facts of the case itself show how the malfunctioning of drones have resulted in the deaths of certain people. And similarly, jurisprudence around the world suggests that there are privacy concerns with respect to the usage of drones. There are also concerns with respect to the weight and the usage of drones in populated residential areas, which is why it becomes a befitting case to apply the particular rules which seeks to govern the regulation of drones in the region. In particularly, your lordships, in the case of Madhubai versus Union of India, a 1961 judgment of this honorable court, it was noted that it was well within the ambit of the state to subject businesses to secure license or to impose certain regulations. In light of the same, the drones rules rules for commercial drones 2016 also merely prescribe that no person shall fly a drone without a certificate of airworthiness, considering that if a drone is being flown that does not confine to the standard of airworthiness, it becomes particularly problematic to the welfare and safety of the general public, considering that drones may result in the damage to public property or human life as well as safety of the people. Additionally, it is important to note, your lordships, that as the counsel for the petitioner have contended that this is an arbitrary exercise of power and whatnot, it is humbly submitted that in the case of Ashwini Kumar versus UPI, the executive is enshrined with certain amount of discretion in order to allow for its expertise to be applied in the field of governance. That means that the decision with respect to what zone constitutes a red zone, as well as with respect to the other parameters that are to be determined, are well within the executive discretion in order to reasonably govern the roles for drones, lest they become a problem to the society in general. And that is why the executive has the primary responsibility of formulating policy and allowing for suitable policy being made for the interest of the general public. That is why it is submitted that the rules pertaining to the grant of certificate as well as with regard to the demarcation of a red zone are all well within the executive's purview to determine reasonable restrictions on the freedom of trade. therefore in no way becoming an unreasonable restraint on the freedom of trade in the region, your lordships. With that, your lordships, the council concludes the submissions in regard to issue 2 by reiterating that there is a strong presumption of constitutionality in favor of the rules for commercial drones 2016, and also stating that under Article 19 Clause 6, the reasonable restrictions can be imposed on the right under Article 19(1)(g) in the interest of the general public, which is exactly what the rules for commercial drones 2016 seeks to do, preserving the interest of the preserving the interest and welfare of the public, which is what the state endeavors to do. Your lordships, that concludes the submissions to be made by the council for the respondents in the present matter. If your lordships have any inquiries with respect to these submissions, the council would be pleased to hear them.
Let me ask just to see your mindset and what is your take on a very simple and a small issue. See, one of the honorable judges in the panel, initially when we started this hearing of the case, and very aptly and rightly observed that there seems to be an unfair comparison of drones and motor vehicle. Two things are separate, two technologies are separate. One, why it is? What is your take on that? One issue. And don't you think it's an unfair comparison of two unlikes? Not likes, but two unlikes. Second is when we talk of role of IT in getting into the laws of the land. Let me also elucidate example of robotics, use of robotics in conducting medical surgeries. God forbid if something goes wrong, is robot to be held responsible, or the person who has deployed the robot, or the manufacturer who has produced the robot, or the person who indemnifies the robot? This is a new arena and unexplored areas of work wherein a lot of things are going to change the future legislation when we talk of employment laws in the country, or injury laws in the country, role of IT. I would like you to comment very briefly because we are running short of time, and so are other judges as well. Very shortly, even if you could summarize in 2 minutes, with 2 lines, not 2 minutes, just two lines, very short, very short.
Indeed, your lordship posed a very interesting question in light of the development of technology and the relation that it has with the legal system that we have. Indeed, a complete equivalence cannot be made between motor vehicles and drones, as your lordship had correctly pointed out, considering that at least with regard to motor vehicles, there is a clear and compact system of how these things are dealt with legally, which is a system that has been developing since the Motor Vehicles Act. As drones are a more nascent technology which operates in the air. Furthermore, these drones are often heavy and can result in injuries to people, and they are still very unregulated in nature. Unlike in countries such as USA and France and so on, the jurisprudence in India with respect to drones is fairly new, your lordship. And that is why there must be utmost care in understanding which principles of motor vehicles law can apply. For example, the rules do prescribe with respect to insurance, and that is something that may be applied in that manner. However, with respect to general provisions, certain technological expertise is to be applied with respect to how drones are approached under the law. With regard to your lordship's secondary question on the use of AI and robotics in medical field or with regard to even general public using these things, it is still an undecided question, and it's an ethical as well as a legal question, your lordship, as to where this liability will be affixed. However, I believe the most suitable consensus can be placed that the nature of default that has happened must be considered. For example, if in a surgery, the manufacturing, the hardware of the robot has malfunctioned, and because of that, the death of the person has been caused, then the manufacturer should be held liable for that kind of defect. However, if it is a software issue that has resulted, that is the algorithm that the AI functions on has defaulted, then the person who has made the code and has allowed for such thing that has happened may be held accountable. Therefore, on a case-by-case basis, law can be suitably applied in each of these cases, your lordship. And that was just a summary of the council's thoughts on your lordship's extremely intriguing question.
And don't you think that the agency who certifies these robots
Indeed.
and give clearances should also be hauled up?
Your lordship,
to some extent, they also own a responsibility to the country, to the citizen.
indeed they hold a responsibility to the country and the citizens, Your Lordship. However, it is the council's belief that the best way that they can fulfill on the obligation is to then take action against the person that has defaulted. For example, if certificate is granted, the certificate can be revoked, penalties can be imposed, and thus the certifying authority then can take action in that manner. That is why the council does not believe the certifying authority would be directly liable, but the certificate authority should be involved in the process of fixing liability.
Right, right. Thank
Much
you.
obliged, Your Lordship.
All right, well said, well said.
Your Lordships would Your Lordships want to hear the prayer from the council for the respondents?
Summarize it shortly, quickly.
Indeed. Wherefore, in light of the issues raised, arguments advanced and authorities cited, the Honorable Supreme Court of Hastinapur be pleased to declare and adjudge that the government notification dated 1st January 2016 should be applicable to the accidents that took place prior to the notification. Secondly, declare that claims under the Employees Compensation Act 1923 and the rules for commercial drones 2016 are mutually exclusive. Thirdly, uphold the constitutional validity of the rules for commercial drones by dismissing the suit challenging the constitutionality. And lastly, upholding the High Court's verdict dated May 2018 in the calculation of compensation, and or pass any other order it may deem fit in the interest of justice, equity, and good conscience. All of which is humbly and respectfully submitted by the council for the respondents. With that, the council submits and concludes the arguments before this honorable court. It was indeed a pleasure and an honor to argue the case before such an esteemed bench. Much obliged, Your Honors.
All right. Now, who is the next speaker?
I guess
Or-
it's concluded, sir.
Would,
Or it is complete?
If your lordships may permit, I may have the permission for presenting the rebuttals in this case, your lordship.
Yes.
Your Lordship, sorry for the interruption in between. It's a very gentle reminder for all the participants as well as for the knowledge of the judges that sir rebuttals as per the rules are not allowed, but if the judges deem fit, they can only be allowed after that. Sir rebuttals.
I could not follow you.
Your
Please repeat.
Lordship, as per the rules, the rebuttals, sir rebuttals particularly, are not allowed, but in case the judges deem fit, they can allow it. Sir rebuttals.
No, they have argued, as far as I believe, they have argued very well. We do not want any rebuttal because this is not a real shoot or matter. We are not going to deliver a judgment. We are only to judge how good they have argued.
Indeed, your lordship.
Therefore, there is no necessity of rebuttal. So all of them have argued very well, and it's very difficult task. We have been put into a very difficult task to judge who is better than the other.
Indeed, your lordship. Actually, it was just a reminder for the participants.
I agree with the lordship. It is indeed a tough.
Now,
I
believe
I could make a minor point before the honorable court. Your lordships, by the rules of the competition, the sir rebuttals are not allowed. But if you would allow, I would like to present 4 to 5 rebuttals because we had reserved 5 minutes for our rebuttals in the competition, your lordships, on the arguments that the respondents have made.
I don't think so, gentlemen. Rebuttals are forewarranted. Perhaps both the parties, both the sides have not only given the citations but have well packed their comments, arguments, and narrations, and they have elucidated very nicely, very effectively. However, I leave the allowing you 4 to 5 rebuttals to be presented by you. I leave to the choice of other judges as well. According to me, I don't think rebuttals are required anymore because both sides have argued very well their cases, their contentions.
I agree with Dr. Dhar. I agree with Dr. Dhar. Now, what is just Mr. Mishra and Mr. Rathod?
I also agree with my learned seniors. Let me not deviate from the general consensus. So I agree with both my seniors panelists.
Yes, Dr. Rathod.
I do also agree that some rebuttals are not required in this matter.
Now, Mr. Orkos, You have argued very well, and we have confronted you in very many manners, and you have responded it to very well. Therefore, we don't think that we need any rebuttal so far as the merit of the case is concerned. We are not concerned with the merit of the case. We are concerned with the process, how well you have argued, and how well you have presented your case. Now we are in a dilemma to decide who has argued better. Let
Your
us see
Lordship,
what
I
by
am indeed grateful for your feedback. Your Lordships, just one point. It is up to the discretion of the court to decide whether the rebuttals would be allowed or not. But since they argued subsequent to our submissions, I have found 4 to 5 aberrations in their arguments. That is why I was seeking for rebuttals. But it is up to the discretion of the court, Your Lordships. I am indeed grateful.
All right, if you are insisting, all right, later, but to take only 4 minutes.
I am indeed grateful, Your Lordship. I am indeed grateful, Your Lordships. Now, Your Lordships, my learned friend, the speaker one from the respondent side, made a claim that they were automatic drones and the control of the drone was with the drone itself. So, cutting edge is not liable. Your Lordships, I would like to direct your attention to paragraph number 9 paragraph number 8 of the Moot proposition.
No, we are not going to
mention
facts. In reply, facts are not permitted.
Not to the fact.
Sure, Your
Lordship. Point, please make.
No, you cannot go to the facts again.
I'd like to make a point that any human intervention that was required was to be performed by cutting edge technology. So the control of the drone entirely was not in the hands of the
That you
drone
have
itself,
already
but
submitted.
was in the hands of.
That is already mentioned.
Submitted. We have noted your argument. That you have argued already. No, you don't say anything what you have argued.
Sure,
you have fact. If you have a legal point, please do raise it. Otherwise, you are wasting the time.
Sure, Your Lordships. With respect to the condonation of delay issue, Your Lordships, it is a well-established doctrine.
Because Dr. Dhar pointed out that this condonation of delay has not been referred to the Supreme Court. Therefore, that's not the question.
Exactly.
Sure, Your Lordship. Then with respect to the retrospective application of the government notification, Your Lordships, I would like to reiterate the point that government notifications are in fact for revision with respect to change of circumstances and conditions of changing times. You do not file for your compensation for n number of reasons. And as soon as the compensation gets revised, gets doubled, you file for the plea and you take the plea.
You have already argued that, Mr. Rarkash, you have already argued that.
Sure, Your Lordship, just to reiterate with respect to the respondent's submissions.
Something which we have not mentioned.
You are supposed to repeat your argument.
Sure,
the governing law of that position is the Shivraman case and the Pratap case, which is already.
In fact, I was coming to that, Your Lordships. The Shivraman case was in fact I was amused that the respondents chose to cite the Shivraman case because in that very case, 10 long years of delay had taken place for the compensation to be filed. And the court observed that it was in the interest and the penalty for default that the compensator had made. And with respect to the changing times that had occurred in the 10 long years. So there were specific reasons for the compensation to be increased, not because of the retrospective effect of a government notification, Your Lordship. So if the reasons have to be proven to the Honorable Court, that is when the court can have the discretion to increase the compensation. But the reasons, I don't see the respondents having submitted any liable reason for them to have an increased compensation, Your Lordship. With that, then, without any further ado, I would conclude my rebuttal, Your Lordship.
They argued the retrospective aspect of it rather than the compensation per se, whether there can be a retrospective application or not. That was the central point. And that's why they cited that Pratap case and the Fasala case. This is what was their suggestion or the submission. Am I correct?
Indeed, Your Lordships. That point be noted. If there is any clarification, then I'm happy to give. Otherwise, I may conclude my rebuttal, Your Lordship.
Also giving you little inputs on the labor law side. For example, the revision of minimum wage is the prerogative of the appropriate government when you have central government and state government. So whenever state government notify or central government notifies, enhances minimum rates of wages, such revised wages do not have a retrospective effect. They are effective from prospective date of notification. So, as I said earlier, in 100% cases, such notification have prospective effect until and unless it is mentioned specifically that it will have retrospective effect from so and so date.
Notification.
In the
Indeed,
notification.
indeed.
Otherwise, they are all from
Indeed, Your
prospective
Lord.
dates. From the date they become notified, they are applicable, they are implementable, enforceable.
Indeed, Your Lordships, and that is exactly what my co-counsel had argued.
We have
during
heard that. We have heard. I'm
his
just
briefing, and
brushing up your memory.
Sure, Your Lord. The co-counsel had argued in the part of his submissions, but with respect to the case Sivaraman judgment also, the court had stated fact that changing conditions are the one that the court takes into consideration with respect to increasing the duly assigned compensation. Other than that, if the reasons are not specified and if it is not specifically mentioned in the notification, that it may be a debate. Court doesn't have any from a and most importantly, the changing conditions and the reasons that the councils may have seeked in this particular case have not been adhered to by the respondents, Your Lordship. That is why,
That's all.
just to revise what my co-counsel had asked.
That's all, Mr. Arkas.
Indeed,
Now
Your Lordships, I am really grateful.
I must tell you that when we were lawyers, the judges used to tell us that you must know where to stop. Therefore, you also learn that. We have
That's true, very true, very rightly said. Aptly said. Justice said, very rightly said.
Indeed, Your Lordship, and I apologize for minor mistakes that I may have.
No, you are a budding lawyer. You must, therefore, I am telling you, passing on my experience to you. I am not advising you, and I am not saying anything. I am just passing my experience to you.
Indeed, Your Lordship, and I am grateful for paying heed to me.
And that was as a lawyer. When I was also a lawyer like you, sometimes I used to over argue, and the judges used to tell, Mr. Seth, you must know where to stop. All right. Thanks. Now it is the part to decide who has done better. Now we do not have any separate compartment for discussing between the judges. Anyway, we are doing it. We're doing it straight away. Now, may I ask Dr. Rajendra Dhar to tell us his view and opinion?
Would request those who are participating.
Yes, sir.
Only the appellant and the respondent. Appellants are Mr. Supinder and Orcus, and respondent is Mr. Joel and Samram.
Seven, sir.
Seven.
Indeed, Your Lord.
Seven.
Seven Ram. Yes. So now we could decide either whether the appellant's team has done better or respondent's team has done better. Joel and Sriram, and then or Supinder or Arkas. Now, Dr.
If I may intervene to the honorable bench.
Yes, please.
Yes.
Yes,
Yes, sir. So let the judges decide participants, and I'll allocate you the breakout sessions, and let the judges decide your scores first among themselves.
Please log
Yes,
out the participants.
Yes, sir. Just a minute, sir, please. Thank you, sir.
Before that, I have a request from all the participants as well as the respected judges. Can we have a screenshot before that for the social media platform?
Sure, sir.
Yes.
So for that, I request each and everyone present in this meeting to, for the minute time, if you can, they can please switch on their video so that we can have a proper screenshot for the social media platform.
All right, please switch on video. Everyone, please switch on your video.
And
it's humble.
Smile also.
Then it will be more better, sir.
Even if the fake ones.
I again request everyone, if it is convenient for them to switch on their cameras, please.
Mr. Abhijit, Abu Shahid, Deepa, Pratik, R. Chaudhary, Shivangi, where are they? All right, let's say cheese.
Thank you so much. Thank you so much, everyone. We are done with the screenshot, and for the participants, you have been allotted another breakout session till the time judges score you. After the judges are done with the scoring, you'll be again called here for the feedback session. Till the time, thank you so much, all the judges and the participants. It was indeed an honor for us as well.
And irrespective of who wins, all of you have done excellent job. You should
Oh
be
yes,
proud of
wonderful,
yourself.
wonderful presentation.
So don't go for who wins, who lose. All of you are very good. We were very happy with your performances, and we wish you all the best for the future in advance.
Thank you, judges.
Yes, judges. The participants are
Yes.
allocated the breakout sessions. You can mark and discuss it among yourselves over here. Thank you.
All right. Thank you. Yes, Dr. Dhar,
As
tell us.
suggested by Justice Seth,
Yes.
I have heard both the parties as very well said by Dr. Mishra that nobody is a winner and nobody is a loser. Everybody is a winner here. Is a wonderful experience of hearing young budding legal professionals coming up the way
We
they
will
have
say all
presented
these
there.
in the, Dr. Dhar, may I
Yeah,
suggest
please.
that
Yes, please.
whatever you are saying, we should say in the presence of the participants so that they are also encouraged. Now we are not on that. We are only
My only
decide.
handicap is I have another meeting lined up at 5:30. I need to move a bit fast, and I would
You just
definitely
tell
wish
us
to
that
congratulate
whom do
them.
you, you just tell us whom do you consider to be number one and who is to number two.
I would, if I am correct in giving remembering the names of the budding guys, Sukhinder.
Yes.
I think from petitioner side.
Achha. Now, is
If
it
I
for
am
the
correct,
team? Is it for the team or for the one candidate only?
it is for the team. It is the team. I have been
Team.
not.
The organizing
It is the team in which
Yes.
Mr. Sukhinder was also
I'm
one
really
of the
sorry to interrupt
speakers and a petitioner perhaps from petitioner side.
your
For the
lordship.
appellant.
Got the marks
I'm
on the
Excuse
basis of
me,
the mark
the
breakup.
Appellant or
organizing committee.
petitioner?
No,
Judges, I'm really
I
sorry to
believe
interrupt.
Mr. Arcus is locked
Yes,
out,
please.
but Arcus is here. He is not locked out.
I got disconnected from my breakout session, so if the organizing committee could allot the breakout session to me again.
You are not supposed to listen to
No,
us.
you are not supposed to be here. You don't log in,
Sir,
please.
You are not.
I had joined the breakout session,
Don't
sir.
log
It
in,
got
please.
disconnected. Please, sure, sir, sure. If I could be allotted the session again. Thank you, organizing committee.
Yes, Mr.
I
Dr.
think
Dhar.
they are the respondents. I believe so. I have noted
I
down the
will
names of the.
Sir, Dr. Dhar and Justice Seth, just 1 second. There are marks breakup, so we can allocate. For example, there are 9 or 10 criteria. For example, how much mark will you give to the team, first team, on the basis of knowledge of law? The maximum marks is 10 and minimum is 0. So I will read out, and Honorable Justice Seth
Yes, that would
and
be
Dr. Dhar can.
that will
That
help
will be
me
better.
in giving a assessment
Yes,
right
yes.
away and
All right.
specifically too.
Yes, Dr. Mishra, please help us.
Please
All
do
right,
that.
sir. So I will first tell you the criteria on which marks has to be given. You can write down and then fill in the blanks.
Yes,
And
please.
then it is going for the team, not for the individual. So the criteria are: number 1, knowledge of law.
All right.
Criteria number 2 is logic and reasoning.